has been been in the field of working in the disability community for a long, long time. Ms. Simon, welcome.
Thank you. Thank you very much for holding this hearing. I'd like to address just a few comments with regard to the impact of the ADA Amendments Act with regard to education and high-stakes standardized testing. The education community, both through K through 12 and higher education, have raised some concerns with regard to the number of people who would be requesting accommodations under the ADA Amendments Act, essentially stating that this would enormously expand the people who would be requesting services under the law. I believe that to be entirely false for two reasons. One is both the K through 12 and higher education community are for the most part covering these students. This is not going to swell their ranks. And secondarily, I think that it's very important that we keep separate the notion of whether one is protected by the Act from whether or not one is entitled to a service under the Act. The Act, in fact, requires reasonable accommodations for those people with disabilities who may need them, and they may need them in certain situations and not in others. So the very fact that one needs an accommodation should not be a litmus test for whether or not one has a disability. That's the second step of an analysis, and that step is not changed at all by this amendment. Mm-hmm. Secondly, the standardized testing industry has raised several arguments with regard to, again, the number of, the increase in the number of requests for accommodations. I believe that will also not change under this Act. The fact is, most people who have a disability are already requesting accommodations when they are taking one of these tests. What might change is the fact that certain people would be extended accommodations on these tests that are not currently because of the bogus and very, very narrow interpretation of the Supreme Court case law. Many of these requests are for the most part denied, not because the request is not reasonable, but because the entity has substituted its judgment for that of the physician and said, no, this person does not have a disability, and applying the Sutton and Toyota standards. To the extent that fears have been raised about the validity of the tests after accommodations have been provided, this is not an issue that is really addressed by this legislation. There is already existing a defense for any organization that if a requested accommodation would fundamentally alter the nature of the test, then it need not be provided. However, these entities are providing accommodations for a number of people with disabilities, and there's a reason for that. One is a blue ribbon panel commissioned by the College Board, who are the people who make the SAT, has already examined this issue and found that extended time, which is the most commonly requested accommodation, does not compromise either the validity or the score comparability. Therefore, I think that these issues that are raised represent fears, represent concerns, but they do not represent facts. Thank you. I look forward to your questions.
Thank you very much, Rosamond. Well, thank you all very much for keeping those comments very short. Yeah, that's okay. Professor Bagensauce was first, I guess,
okay,
or
good.
something.
Well, it is quite clear under the case law that it's an obligation to accommodate a disability that's known, or at least that there's some particular reason to believe that the covered entity should have known, right? So that's saying you don't have to go out and see whether this person has a disability. And these other kinds of obligations under IDEA, I think we really can. I think you're right, Senator Harkin. We can really deal with them as separate and deal with the terms of this statute as the terms of this statute.
I'm tracking on that one. Anybody else want to comment on this at all? Oh, I'm sorry, Ms. Simon.
Yes, thank you, Senator. I think that the issue about LD gets raised all the time in terms of low performance. There are two reasons why this might happen. One is a common misconception that learning disabilities are the same thing as low intellectual ability. They are not. So the fact that somebody who does well with accommodations or does well because of the class size or what have you, doesn't mean they don't have a learning disability. A learning disability is a processing disorder. It's not an academic disorder. It may be demonstrated in academic difficulties, but it need not be demonstrated in academic difficulties. And the problem is when you try and make one thing something else, you then lose the essence of what it is. It's very important that students with learning disabilities get the right kind of instruction. And to the extent that the chart that was shown before indicates that they fall off along with students who have low achievement may in fact be an issue with regard to instructional responses, as opposed to whether or not those students have a disability and would be protected by the law. I think that the way that we can be assured that we are protecting students who need protection is to have a thorough, comprehensive clinical assessment of how that child learns. That will separate out those students who have a processing disorder, a learning disability, from those who have an academic disorder.
Applied. So as you just heard from Joanne Simon, someone with a learning disability is different in the manner in which they learn.
So the person who walks with 2 artificial limbs is walking, and he may actually walk quickly in certain circumstances, but he's doing it in a fundamentally different way, in a materially restricted way. I think what's important is to make sure that we're comparing like things. When we compare performance outcomes to the manner in which someone performs, we end up comparing apples and oranges, and we end up with fruit salad, and then we're just confused.
There is no confusion, Mr. Grossman, I don't believe, in the House reports on this. What there was an effort in the House reports to undo the fruit salad, okay? What there was an effort with regard to learning disability to explain what Joanne Simon just said, that when you decide whether someone with a learning disability is materially restricted, you don't look at their final outcome. Oh, did they get A's? Because maybe they did get A's. You look at whether their manner, duration, condition of performing the life activity is different than that of most people.
Here's a person who, correct me if I'm wrong, Mr. McClure, who was hired to do a certain job, had done this job for many years before. The doctor who examined him found out, or through the examination, that he couldn't raise his arms above his head, and therefore declared him to be disabled, basically. Well, GM didn't hire him. Well, he took it to court, and the court said, you're not disabled. So he never really got to ever get to the merits of his case. So it seems to me this is a profound instance of where someone was carved out from the first prong and was never allowed to ever be heard on the merits of the case. Mr. McClure never ever got to the merits of his case. And so that's why I point to this and say that somehow this has got to be more broadly construed so that people can't just be carved out without getting to that next step. And so it seems to me we have to have this construct in this bill somehow. It's very frustrating when people with epilepsy, amputation, and you think about all the veterans coming back from Iraq who are going to have a lot of prostheses and artificial limbs and stuff. They might be able to function pretty well, but if they were ever discriminated against, they will never ever have their case heard on the merits because they fall under here, what the Supreme Court's now decided. So I think this is, again, one of the essential elements of this bill, that we have to do it right and make sure we have it right. And I was just asking if what you thought about the construct in the bill itself. I'm not hearing anything opposite, what I'm hearing is that that what's in the bill is good, is acceptable.
That it's very important that, again, we keep our eye on the ball with regard to what it is we're trying to do here. We're trying to cover those people who Congress originally intended to cover and who have been denied those protections by the courts.
Okay, I would invite you to submit some more testimony and some stuff to us elaborating this. We'll be looking at this very closely. And if I don't go, I want to thank all of you for being here. And more than that, I want to thank you for your involvement in this process for a long time. We will be working on this legislation this month. Hopefully we'll be able to move something. I hope to get it done this year. And with your help, I think we can do that. So thank you all very much.